number 141, the people of the state of New York versus Alex Flores and others.
Good morning, Your Honors. May it please the Court, Robert Middlemiss on behalf of the people. We would request 2 minutes of rebuttal time.
You may have your 2 minutes, sir.
The Appellate Division erred in finding that the trial court was unable to impanel an anonymous jury in 3 respects. In the first instance, the court as a whole adopted an incorrect reading of CPL 270-15 1A and 1-A. This court has consistently said that a literal interpretation of the statute will be rejected if it fails to give authority to the clear legislative intent of the legislature in passing the statute.
Well, you would agree that 1A was enacted after, 1-A, right? Was enacted after 1A.
Yes, Your
right?
Honor.
And so the fact that the second enactment specifically gives permission for the withholding of juror addresses, doesn't that at least suggest that the legislature did not intend to also include names in that, since the two are very different? One says you must, and the other one says you don't have to, for 2 different things.
Well, Your Honor, thank you. The two are indeed very different, but they are also very interrelated. Particularly today, revealing the name of a juror will almost instantaneously reveal the address as well.
Well, that may be, but isn't that argument best presented to the legislature? How do we read something that seems to be inconsistent with the language, the plain language of the statute?
Well, this court has consistently adopted broad readings of statutes, particularly 270-15, to offer courts the discretion necessary to enforce the clear legislative intent.
Which of those sections are you suggesting we read broadly?
Both, Your Honor, both.
So you're suggesting that we can read addresses to mean names?
Yes, Your Honor. Well, if I may, we can read addresses to mean addresses and names.
Okay.
Certainly the intent was to protect jurors, particularly by their addresses. But again, the main reason that names are relevant is because without protecting the names, there's no protection at all today.
Let me ask you this. I noticed that in 1A, the questionnaire lists a number of things that you can ask the jurors, including place of birth, current address, education, occupation, but it doesn't list name. So why isn't it a reasonable reconciliation of 1A and 1-A that the reason 1-A doesn't mention names is because 1A contemplates the jury questionnaire doesn't have to have the name on it in the first place?
Well, I think that certainly that is a reasonable construction. At the same time, it has to be acknowledged that names are expressly identified in 1A in the sense that the court is, in theory, required to identify the jurors in bringing them in by name.
And where do you draw that from? What portion of 1A says that?
The initial portion of 1A indicating that jurors should be called by name and then placed.
Does called by name mean called publicly by name? Or, for example, somebody goes and says to the juror, okay, you're it.
Well,
isn't there a use of the verb call? You know, I was called to the bar. I was called to the clergy.
To be fair, it is certainly the common understanding of called, but certainly, I mean, I would agree that.
Could the person be
such
called by his first name or her first name only? Would
Well,
that
that's
satisfy
entirely
all?
plausible. I mean, it is a reasonable construction as well, Your Honor, yes.
Counsel, let's say we agreed that there's room here for an anonymous jury.
Yes.
Would, especially in your reading, that address would include name, would that mean the anonymous jury would have to be impaneled consistent with 1A, that is, that the defense counsel gets the names and addresses? This isn't traditionally done in federal court, right?
Correct, Your Honor.
So
Correct.
what would it be in state court under your reading of this statute?
It would be consistent with the statute that the defendants should receive the names and addresses.
And that didn't happen here.
The defense counsel.
Defense
Defend-
counsel.
Yes,
Defendant.
thank you, Your Honor, my apologies, yes, defense counsel.
And that did not happen here.
It did not happen here, but we would submit that what the court did do was substantial compliance, and that the court agreed to provide defense counsel with the names at the conclusion of the trial. And counsel for defendant Aguilar actually filed a CPL 330 motion in which he challenged the issue of the court's decision, but importantly, did not make any reference to any information that was revealed based on his receiving those names.
How do you deal with the underlying problem of the court, by not identifying the jurors by name in public, undermines the presumption of innocence in the conduct of the trial? In other words, by not giving out their names, people can maybe rightly, maybe not, assume that this person is so dangerous that we have to have an anonymous jury. And the mere use of an anonymous jury would therefore undermine the presumption of innocence that every defendant has when he comes before the court. So it seems that we've been inevitably faced with an arbitrary situation where for some defendants, we say, well, this crime, they're not going to undermine the jury, so therefore the jury's not anonymous. But in this crime, they may. But if we apply our presumption of innocence, which is a core value in our criminal cases, it seems that it's in danger of being undermined.
Well, that certainly is a factor that courts necessarily balance in making that determination.
Well, that's what I'm wondering. See, your response is reasonable. I don't mean that. But can the presumption of innocence be balanced? Can you balance that fundamental value against anything, or is it something that we must stick to, and the consequences are the consequences?
Well, the statute, 1-A, clearly recognizes that it is possible to balance, in part because it authorizes both parties to seek to have an anonymous jury. There's a clear recognition that the presumption of innocence is merely one factor.
So
The
as I
desires for-
understand it, under the federal system, there also has to be a neutral instruction to the jury, and that is intended, I think, to provide some of the balance as well. That did not happen here. Is that fatal?
No, Your Honor. No, Your Honor.
Why not?
State and federal courts have consistently offered different opinions on the issue. There are a number of courts who have said that it's particularly important to have that. Massachusetts, for example. Other courts, such as Nebraska and Tennessee, have said that it's perhaps best not to offer any instruction because that in and of itself could lead the jurors to conclude that something was unusually dangerous.
So,
based on the
counsel, let's say
situation.
we agree with you on this statute authorizing a judge to impanel an anonymous jury. What was the basis here? Doesn't that depend on the individual case? What's the basis here for the anonymous jury
Yeah.
being impaneled according to the judge here?
The court was clearly aware of a number of circumstances related to the case because the court's decision immediately followed the combination Sandoval-Molyneux hearing in which the defendant's history...
But what did the judge say at the time? At
judge
the actual time that the judge was going to move forward with impaneling an anonymous jury?
At the time, the judge made reference to his history with jurors and their expressed concern about their names, and also the physical conditions outside the courthouse at the time, particularly the parking, which jurors had expressed...
So if none of that is specific to the case, even assuming we agreed with you that the statute permits a judge in his or her discretion to make this determination, how would that have been an appropriate determination in this case if it's based not on the facts of the case and the defendants before the judge?
Two things, Your Honor. First, it clearly was based on the facts of the case because the judge was necessarily aware of them after having just reviewed them with the parties. Second, things like the condition of the parking lot, they are consistent with what has been recognized as relevant in terms of juror protection. One of the factors commonly recognized, for example, is the publicity of the trial.
But the anonymity of the jury doesn't protect anything going on at the parking lot. You don't need to know somebody's name or address.
That's very true, but it clearly limits what can occur. In this case, you actually had Defendant Aguilar, the only defendant out on bail, along with a number of his associates, whatever their connection, waiting in the parking lot next to the car of one of the
But even the judge
panel
said he
jurors.
couldn't reach that conclusion. If
Respectfully,
the judge didn't reach that conclusion and it doesn't inform the judge's decision, then we can't rely on that here.
And that was also after the decision had already been made.
well, thank you, Your Honor. As the
to
dissent
panel.
clearly recognized, the analysis must be retroactive. You can't tell the defendants to unhear jurors' names. It's either or. Clearly, the court was aware of the
No, but you
defendants.
can't rely on something that allegedly occurred and for something that you decided before that ever occurred.
Well, again, the dissent felt that you could, with respect to at least the addresses, which the dissent agreed. Importantly, Watts, the case the parties generally cite, the court there noted that it had to be prospective analysis. If there was a concern over jurors' safety, subsequent occurrences that reflected that there was merit to that concern absolutely reflect back on what the court
Right,
decided
but there
at
has
the
to be
time.
some basis at the outset for why one would be concerned about juror safety. And as I understand the record, the judge didn't base that determination on concerns related to this specific case, just the judge's experience and what other jurors had said to this judge.
Well, if I may, Your Honor, obviously, specific rather than implicit identification of concerns would have been far preferable. But the court had just heard the fact that the defendant's criminal history, particularly defendant Ramirez, was relevant in the sense that, one, of course, they were all gang members, consistently identified as relevant. But Ramirez in particular had previously been charged with gang assault in the first degree several years before. And his immediate response had been to abscond to, I believe, Nebraska, where he remained for several years before returning, at which point he conveniently pleaded to a misdemeanor because it was impossible to prosecute the case
But in
at
that
point.
example, he
That
didn't
wasn't
threaten anyone. He left.
true. But, again, the point here was Defendant Aguilar was the only one out on bail. The only one out on bail. And then, therefore, he was the only one who could potentially flee.
Thank you,
That-
counsel.
Thank you, Your Honor.
Counsel?
If the court please, my name is Leonard Levinson. I represent the respondent. 150 years ago, two legislatures, New York State and the federal government, decided that criminal trials should be open and public.
Counsel, let's move up a little bit into
I'm
the
sorry.
present. Your view, I understand it is, this is never authorized, an anonymous jury.
Anonymous jurors certainly are authorized if there's a good cause or reason to.
So you would read that ability by the trial court to do it into the New York procedural law?
Absolutely.
And what conditions could the court order an anonymous jury?
Well, the obvious ones, if you have a mafia gang being tried for murder, they have a long history of abusing witnesses, I would say you have a situation there.
There's a Fifth Circuit case, US v. Kraut, it sets out a test. Are you familiar with that? There are 8 different factors that they ask the court to look at. Is that something that we should consider?
Yes, of course. I would, but I...
And would you agree then also that if we were to find that type of procedure available, it would need to be consistent with 1A, that the defense counsel would need to have the names and addresses?
Well, I certainly think there's nothing wrong with giving the defense counsel the names and addresses of these individuals. I think Judge DeRosa said that if you give the names and addresses to defense counsel, they have to turn it over to their clients. That's not true. They don't have to turn it over.
Well,
They
I
could be
and I assume
direct-
that the protective order referred to in 1A could, if necessary, expressly say counsel cannot disclose these names to anybody. Is that right?
I believe that they could be disclosed to defense counsel.
No. What I'm saying is 1A specifies that the court may issue a protective order. You with me so far?
Right.
That protective order could say, I'm disclosing the names and addresses to counsel, but they are not to disclose those names to anybody else.
Yes.
What went wrong here, counsel?
I'm sorry.
What went wrong here?
Well, what went wrong here is the is the statement by Judge DeRosa that I'm going to do this in every case that comes before me. I'm going to have an anonymous jury in every case that comes before me, whether there's reason or there isn't reason. I think in this particular case, he mentioned the garage incident, the parking lot incident. That itself, I think, is not necessarily conducive to anything. I mean, it's a question of whether or not he was actually looking at the witness, whether the witness was
Right. Counsel, he
concerned
also
what have you.
offered, the trial judge offered to give an instruction, and there was disagreement among defense counsel as to that appropriateness of that instruction, right? Consent.
Well, it seems unfair to the three individuals that wanted the instruction just because one did not want it.
Could the judge have given that instruction despite the objections?
Judge could have given that instruction, but I don't think it would have been dispositive of the issue. Even the fact that he did give such an instruction would not have made it dispositive.
So, taking it along in your view, there is a possibility to do this. It was not done properly here, so it's a violation. And what is your view of whether this is per se error or which standard of harmless error should apply?
Well, we're talking about the issue of harmless error. We have two issues here. First, it's a constitutional issue. The Constitution says that all trials, criminal trials, shall be public. Our legislature on many occasions passed that.
If it's a constitutional issue, are we saying that it's unconstitutional to, by statute, allow, for example, the withholding of addresses as our statute does?
I'm sorry, I missed the last part.
So if we're saying that it's unconstitutional, that it has to be a public trial and all this information has to be made available, we have a statute that allows the withholding of jurors' addresses in certain circumstances.
Right.
Is that unconstitutional? And
Well-
is the federal analysis, is that unconstitutional?
Well, it's not necessarily unconstitutional, but certainly the trial should be reasonably open, the extent to which
Well,
it's...
isn't the question, can the trial be public, but the jurors' names still be anonymous?
I don't see how that can be. We're talking about, I started mentioning 150 years ago, we were talking about small towns where everyone had a right to know what was going on. If you give up the right to the name of the particular individual, I think you undercut very substantially the public nature of the crime.
Thank you.
Thank you, counsel.
Thank you.
Counsel?
Counsel, can we start with that point of assume, even if there isn't an anonymous jury procedure available, it wasn't followed here, just for purposes of this question. what would your position be on the error standard?
Thank you, Your Honor. It's absolutely harmless. Virtually every other jurisdiction...
Under what standard? Constitutional harmless error or not constitutional?
Not constitutional. No other jurisdiction, state or federal, has recognized a constitutional right to the names of jurors. New York shouldn't be any different than that. This is fundamentally different from rights like participation in response to a jury note, in which it's a question of defense, the ability of the defense to take an affirmative role.
But why is
Whereas
it more
this is-
like shackling? You shackle a defendant, you didn't have the proper basis for doing it. Don't we apply constitutional error to that?
Yes, Your Honor, that's true, but I would submit that this is more like voir dire in general, because that's what it directly relates to, so that you
Well,
would need to show that...
doesn't it also relate to the conduct of the trial? That is, if I know the neighborhood that one of my jurors lives in, I can use that in my argument, my opening. If I know something about the other characteristics of the jurors, I can also use that in examination. It's not just voir dire. It's
Well,
the whole
that-
conduct of the trial, no?
But no, to the extent that you're going to use the address, it's going to be relevant to
No.
voir dire and the...
Not disclose it, but if I know somebody lives in a particular neighborhood, I might phrase questions in a certain way, I might phrase my opening or my closing in a certain way to pitch something to that juror. No?
It may be relevant in that sense,
Which is
certainly,
conduct of the trial, it's outside of the voir dire.
but it's no more interrelated than anything else relative to voir dire. I mean, if you know any other aspect of their history, where they were employed, what type of...
But under your rule, wouldn't counsel know the neighborhood under a protective order? I mean, you just couldn't mention it in court, I would suppose, but you would still have the information.
Very true, Your Honor, yes.
So going back to why would the standard be different for someone who is shackled or dressed inappropriately and in prison garb, identifiable? Why would the standard be different here? Because what's the difference in terms of the perception on the jury, right? And that's what we're concerned about here. Anonymous jury, this defendant must be dangerous. Somebody shackled at counsel table, this defendant must be dangerous. What's the difference?
I would submit that it is the same reason that the courts have differed on whether or not a jury instruction is advisable or unadvisable. In the case of things like shackles, the danger is that it will be omnipresent, whereas this is merely a one-time thing at the initiation of the trial. Moreover, there's the
Well, no,
recognition...
I don't know if that's correct. People v. Buchanan was a shackling case, and I had it at the appellate division in the 4th Department. And I don't know if you're familiar with it, but he had shackles on during the entire trial initially, and on the retrial, and it was exactly what the Judge Garcia is saying. It required that there be a hearing and a determination that shackling was necessary for a public safety reason. And I sense that that's what's being suggested here in the same kind of analysis.
If I may, it's a different analysis in the sense that the statute clearly recognizes that not only the people or the court, but defendants themselves can request an anonymous jury as well. There's a clear recognition, whereas in the case of shackling, that's not going to be at the request of the defendant. There is the one case in which the defendant declined to change clothes, which caused the jury to see the shackles. But that's an instance in which it's going to be enforced upon the defendant necessarily. But there's the recognition that in the case of something like this, it's entirely plausible that you would have the defense agree that the benefits outweighed the cost. In fact, that was the case in People v. Owens, the Monroe County case where this came up. The parties both agreed that it was warranted. And notably there as well, the court declined to give the curative instruction on the theory that it would be unadvisable because it would highlight the unusual situation for the jurors.
Thank you, counsel.
Thanks so much.